AI can be a very useful thing to use as a lawyer, but more often than not, it will tell you a pack of lies. So we have Matilda. And we all know Hilaire Belloc's Matilda, who told such dreadful lies it made one gasp and stretch one's eyes. Her aunt, who from her earliest youth had kept a strict regard for truth, attempted to believe Matilda. The effort very nearly killed her. The clue is in the title. Artificial does not mean intelligence. And we start off with some lessons from America, because a couple of years ago, the BBC reported that a case in America, Mr. Schwartz had produced documentation created by large language model AI, ChatGPT. 7 cases didn't exist, and the rest that were cited and summarized were, according to the judge, utter gibberish. They were each fined $5,000. That is the 2 lawyers involved, the lawyer's supervisor, and the firm, all $5,000. I'd have doubled that, frankly, but that was the punishment. So your large language model, AI, does one thing to begin with. I don't know if you've heard the outcry from all of the authors about Meta, but they scrape all the available written data from anybody's work, and they stick it in this massive database, which is probably the size of a matchbox, but it's all in that database. So it gobbles up all of that data and then vomits it out in a superficially plausible manner. The siren call is the answer to the busy lawyers. Oh my God, I've got to research this. I've got to draft something. I've got to get it done. Right, I'll just go ChatGPT, give me some particulars of claim for, I don't know, a possession case. In it comes. Interestingly enough, I typed it into Google and it brought up this result: legal document creation. AI-driven tools can now automate much of this process. Hurrah for AI. This automation not only reduces human error, sick, but also frees up lawyers to focus on more strategic matters. My advice is beware, and beware with a capital B, and indeed a capital W as well, so beware. Because they flatter to deceive. Everything that comes out of this process sounds plausible. It sounds accurate, but you need to check it. Check it and check it again. And when we come to this jurisdiction, you probably all have heard, because it has been reported, and legal commentators, Joshua Rosenberg and all, have picked up on the case of Ayinde and Haringey. It is worth reading this judgment in full, and the President, Dame Victoria Sharp, gives us a cautionary tale. It is important, well, not only for the reasons given, but if you are supervising a trainee, a paralegal, or a pupil, or indeed a solicitor apprentice, you as the supervisor need to be aware. Check their working out. If they give you a legal document that they have drafted, check their working out. Because the consequences can be really rather severe. Dame Victoria Sharp noted artificial intelligence is a powerful technology, a useful tool in litigation. And of course it is. When one is dealing with large-scale disclosure exercises, finding some sort of hyperlinks to a particular document, that can work beautifully. But when drafting your own work, whether it is pleadings, advice, skeleton arguments, position statements, case summaries, whatever it may be, it carries serious risks. The risks of using artificial intelligence are now well known. Large language models such as ChatGPT are not capable of conducting reliable legal research. And it is very well worth reading the judgment, and in particular that paragraph, in full. Lawyers have a professional duty. And of course, as you all know from the case of Nettleship and Weston, which just popped out from the back of my mind, about the learner driver. It is a duty you have as a learner, but it is also a duty you have as a supervisor towards that learner to check the accuracy of that research before filing it in pleadings, skeleton arguments, grounds of appeal, or whatever it may be. If you do it in advice, you're letting your client down, and that has serious professional consequences too. The consequences include regulatory investigation, public admonition, and in IINDE there was plenty of that going on and a little bit spare, costs, wasted costs, contempt proceedings, and even a referral to the police. And the only note I've got further to that is, ouch. If you want any of those things to happen to you, then you're probably in the wrong job. So IINDE was just an application for judicial review under section 1883. It's the power of a local authority to provide interim accommodation under the Housing Act of 1986. On its facts, it was an absolute slam dunk of a JR. The claimant was always going to win. But what followed was a tragedy of Sophoclean proportions. So references were made in the grounds of appeal to cases that just didn't exist. The favourite of mine was referenced to a case in 2020, was actually an appeal concerning a charity's liability to pay business rates, which in a judicial review for interim accommodation was quite astonishing. So then the lawyers for the respondent pointed this out, and then it got even worse. And you may better serve your organisation by giving attention not to the normative discoveries you have made. Again, answers on a postcard. I've no idea what normative discoveries are, but whether you can locate the authorities, asking them to spend more time locating authorities that the other side had made up. The judicial review had merit and was settled. However, an application for wasted costs followed. And it came to light during the course of the hearing as well that the counsel who had cited these false citations had a bit of form for doing it, because it had been done in front of the county court, I think at Willesden, in front of a circuit judge, and couldn't do the hearing. So the other counsel who turned up said, well, I can't find them. I don't know what she's talking about. So there we go. So all I will say is my advice is this. Do not use a large language model AI program to draft your court documents. Do it yourself. It is what you have been trained to do. If you must use it for research, then take a leaf out of the book of Santa Claus. Check it once, check it twice, and see which are naughty and which are nice. So check it. If you get caught using it, my advice to you is fess up at the earliest possible opportunity. Doubling down will lead you into serious trouble, because if your opponent doesn't notice the fake citation, you can bet your boots the judge will. And if the judge notices it, you'll end up in the divisional court being hauled up on an application for contempt or for wasted costs. And if you are a supervisor, you check that points 1, 2, and 3 have been followed. And my advice for the supervisor is check points 1, 2, and 3 again. The IINDE judgments also has an appendix which contains foreign and domestic cases, and they're well worth a read. But like I say, my favourite, and I'll just call it up here. Thank you very much to the President for all of this. The United States District Court for Minnesota was concerned with a case concerning deep fakes. The parties relied on expert evidence about artificial intelligence. One of the parties' experts had used generative artificial intelligence to draft his report. It included citations of non-existent articles. The district judge said, the irony. A credentialed expert on the dangers of AI and misinformation has fallen victim to the siren call of relying too heavily on AI in a case that revolves around the dangers of AI, no less. If all that is a little bit meta for you, I can completely understand. The Vagrancy Act of 1824 is to be repealed. Not before time, I hear you ask. One of the things it does do is repeal the provision that makes it a criminal offence for every person wandering abroad and lodging, and then leave out a few words, in the open air or under a tent. So it basically decriminalises effectively rough sleeping. The other thing which is going to go, which I think is a shame, is the definition in 1824 of somebody who escaped from lawful custody was an incorrigible rogue. And I'm sorry that that definition is going to leave the statute book, because it's a phrase I like very much indeed, and it might even have been used by Geoffrey Chaucer. One never knows. Apart from that, specific performance in disrepair claims, I've made the point in the notes, but if you are facing a claim for disrepair or bringing a claim for disrepair, please do bear in mind that there is authority, and the leading textbooks say so. But if you are either agreeing repair works to be done, or they are being ordered against you, be specific about what is required. Because it is becoming all too common for parties to agree the works contained in the report of Mr. X within 56 days. And then there being a massive factual dispute about whether those works were actually in the report, or whether those works have been done, or whether they haven't been done. Set them out in terms. Do your level best to do that. Be precise about them. And also, CPR 70.2 capital A is worth a look if you're a landlord. Because if you get an injunction requiring the tenant to provide access, let us say a tenant has answered an advertisement on Facebook. Other social media channels are available, I understand, saying, get yourself thousands of pounds if you're a council tenant. And then they sign up to a CFA. And then the solicitors kind of advise them not to let the landlord in to do any works, right? Until they've issued a claim and built up a significant amount of legal costs. You could get an injunction. And if you are the landlord and you get that injunction, CPR 70.2a means that you can then apply to the court to go in and do the works yourself. The court can direct that the act be done, that is inspection and repair, by the party by whom the order was obtained.